Should you start with a patent, trademark, or copyright? Hello, Innoventors. My name is Karima Gulick, registered patent attorney and intellectual property attorney. And today we're going to dive into whether you should start with a patent, trademark, or copyright. When you're embarking on a new journey, sometimes the budgets can be of concerns. That can also be the case as you're growing and scaling. So in light of that, I just wanted to go over whether you should start with a patent, a trademark, or a copyright for your business. And the answer is always, of course, it depends. Right? It's going to depend on which tool is going to best protect your work. If you have a brand new invention for a system, a software, a hardware, or a new method, then a patent is going to be the best way to safeguard that. And then for patents, there is a ticking clock there. You have 1 year from the time you start telling people about your invention or from the time you start selling it to get a patent on that. So with that consideration, you might not have that much time to actually file at a minimum a provisional patent application or design patent for depending on what you're doing. So bearing that in mind, you have 1 year from that time starting when you are disclosing your invention to the public or when you're starting to sell it to get that patent. So you might not have that many options there, knowing that statutory bar. The second one is a trademark. Ideally, and what I recommend to my clients and potential clients and any entrepreneurs or startups that are starting is make sure that the mark is clear. If you're not even going to file a trademark application with the United States Patent and Trademark Office to get a federal registration, at a minimum, do your due diligence. Go in there and make sure that the mark and variations of the mark that you want are not taken up and are not used by others. Because for trademark laws, you are going to get some rights just by using it. You're going to get some common law rights there, but they're going to be geographically limited. That is, if I start a cafe in LA and call it Flowers, someone else, I might be starting in January 2025 and I have a priority to that date. So I can stop anyone else in LA from starting a cafe named Flowers after me. But if they're in Massachusetts, for example, and I'm trying to grow, I will not have priority in Massachusetts and I won't be able to grow there. So if budget is a consideration at the very beginning, at a minimum, do your due diligence for trademarks. Lastly, copyrights. Copyrights, ideally, you want to do that once you create the work and as soon as you start selling it, and that will apply to our work of artistic value. So if you're an artist, if you're a creator, if you are painting, if you're taking photos, if you're writing plays, if you're creating music, you want to get that copyright application and registration pretty soon. So what happens if you don't get it right away? You can always file a copyright registration down the road and later. However, the caveat is if someone copies and infringes on your work, you're still going to have to get that copyright registration and application filed with the Copyright Office. Then you're going to be able to take that case to federal court. However, now you might not be able to collect these attorney's fees and additional statutory damages that could have been applicable had you filed before somebody copied your work. I hope this helps. But to answer that question, it really depends on your type of work. There are some items that come with time sensitivity. That is the patent with that 1 year from the time you start selling or disclosing your idea to the public. And with copyright, you get higher damages if you have a registration before someone copies and infringes on your work. If you have any questions, comments, or concerns, please make sure to drop them below and let us know what else you want to hear from us.